Should your estate plan include a charity? I want you to be careful of these 4 things. My name is Philip Ruce. I'm the estate planning director at Stone Arch Law Office. We're a Minnesota law firm, and we work with families on these exact problems to bring a solution. The first thing I want you to worry about is I want you to be very careful about your IRA and who gets it. These are great for charitable giving. I would rather you gave IRA money to a charity than give it to a person, as long as there are other assets you can give that person. If you must give to a charity, this is a great way to do it. Remember, IRAs are tax deferred, at least traditional ones are, same for your 401k. So what you can do is you can list the beneficiary as the charity or a partial beneficiary designation to a charity. And what happens is this charity is going to get that money and they're not going to pay tax because qualified charities don't pay tax. So if you're going to give something to a charity, this is the way to do it for sure. Also, when it comes to your RMDs, your required minimum distributions, you have to start taking these when you're in your 70s. It depends when exactly based on your date of birth, but these are minimum amounts that you must take from your IRA, typically pay tax on it. If you have other assets and you don't need that IRA money, this is a great thing to direct directly to a charity. They're going to get the RMD dollars and they're not going to pay tax on it at all. It's called a qualified charitable distribution, and your IRA custodian can help you with that. Another thing that gets taxed during our life is any sort of asset that is appreciated. So if I bought a share of Apple stock for $1 and now it's worth $1,000, well, there's $990 of capital gain built in there. So if I sell that stock, I'm going to pay tax, and then I'm making a donation of a smaller amount to my chosen charity. If you gift that appreciated asset directly to the charity, they're going to sell it the same way you would have, but they're not going to pay tax because they're a qualified charity and they don't pay tax, right? So that is a very good thing to give if you want to make a lifetime gift, are these appreciated assets to the extent you're able. Don't impoverish yourself. If you need your Apple stock, don't give it away. But you can always take advantage of this in your estate plan as well. On that same note, point number 3, appreciated assets at death, there's a reset. It's called a step up. And if I have that same share of stock, Apple stock, that's worth $1,000 with $999 in gain on it, at my death, that gain's going to go away. So my previous example was for a lifetime gift. This is an after-death gift. After death, my appreciated assets stop being appreciated for capital gains purposes. So I can give that stock to my kids and they're not going to pay any tax at all. So if I'm trying to decide during life, do I give someone this appreciated asset or IRA money, you might want to consider waiting and giving them the appreciated asset tax-free after death, and then the IRA money can go to a charity, again, completely tax-free. So take advantage of that step up in cost basis. And lastly, remember, anytime you're gifting money out of your estate, that money is no longer in your estate for estate tax purposes. Minnesota doesn't have a gift tax. So, and there's a little bit of a look back. There's a 3-year look back, so be careful. But if I gift money out of my estate and then it's 3 years later and then I die, that money does not get taxed to Minnesota estate tax. It's gone. So anytime we're making these charitable distributions, yeah, we're saving on income tax, we might be saving on capital gains tax, but we're also minimizing the value of the estate, which simultaneously avoids another tax potentially. Whether your estate is subject to estate tax anyway or is highly dependent on net worth and how many assets you have. But regardless, this is a problem we work with families all the time. Again, my name is Philip Ruce at Stone Arch Law Office. Book a call on our website, stonearchlaw.com, or you can contact our office directly at 612-444-5555.